All right, welcome everybody to the Northwest Arkansas Commercial Meetup. We're really excited for tonight's meetup. Again, this meetup was created for the commercial real estate investor in Northwest Arkansas. Some of you guys have been to some past events, and there's some new faces here for sure. So just a recap, we started this group to be open to commercial real estate brokers, investors, anybody in the commercial real estate space. We think there's a really big need for that, to have this kind of collaboration. In Northwest Arkansas, there's a lot of single family meetups, but not so much on the commercial real estate side. So I'm Brian Wagers. I'm a principal at Elevate Commercial Investment Group. We recently closed on Watercolors. If you're familiar with that asset, we're looking at other ground up developments here in Northwest Arkansas. We have 5,000 units across the country. The last close was a deal in Rapid City, South Dakota. So we're pretty market agnostic. We just like buying multifamily properties. We have assets. We haven't told anyone yet, but it's 506C, so I can talk about that freely. We're getting ready to launch a deal in Overland Park, Kansas. So if you're familiar with the Kansas City area, it's a really nice part of Kansas City. So I'm excited to be putting that one out there. I got started in real estate investing about 7 years now with a single family property in Springdale, Arkansas. Grew my portfolio to about 500 units. So small multifamily, 12 units, 20 units, 50 units, 80 units, 14 units, and until I expanded and came on with Elevate. Now we're buying, 100 units, 300 units, 400 units at a time. So tonight we get a very special speaker, Denton Woods. Misi will go into his intro. But what I'm really excited about tonight, one of the reasons I got invested in real estate, and more specifically multifamily real estate, was not only the growth of my net worth and growth of my capital, but the preservation. So I strongly believe that multifamily is one of the best risk-adjusted basis places to invest your money. Yes, there's other more maybe high return on your money, but there are more risky. Maybe you have lower return on the other spectrum, CDs, putting money in different investment vehicles, but we really get to dive in today about not just growing your wealth, but once you get to certain milestones, which I think we're all striving to increase our net worth, increase our reach, as how to protect that. So Misi can dive more in on Denny's bio here.
Yeah, absolutely. And also, me, similar background as Brian in terms of I love focusing on commercial real estate, love passive investing. Just in case you guys are in the residential space, thinking of just like having your personal portfolio, just always think about you don't always have to be handling tenants and toilets. You can always passive investing. So that's kind of how I got started from single family duplexes to passive investing. And recently, I launched a fund with one of my fund partners, a customizable fund to help people, compound, whether investing faster with smaller minimums for accredited investors as well. And before that, we're doing like deal on one-on-one basis as well. So, passive investing, like we're talking about asset protection, estate planning, and that's kind of similar to what Brian's talking about, is less risky as well. So coming back to the topic of estate planning, I want to introduce our speaker, Denton Woods. So he has a lot of certifications and has many big hats. I'll just go through the bio and highlight a few key things, and I'm sure he can cover anything I may have missed as well. But Denton has begun working in the RMP LLP since January 2006. He joined as an associate attorney in August 2007, and then became a partner in January 2012. So men of accomplishment, as you can tell. From an education standpoint, he received his undergraduate degree in business administration from the University of Arkansas. And he also had his law degree with honors from the University of Arkansas, and his master's degree of laws in taxation from the University of Florida. So he's not just expert, in estate planning, but like tax, a topic that all of us are concerned about. So he can practice not just in Arkansas, but also Oklahoma and Texas, and before the United States Tax Court as well. So a very accomplished individual. And some of the big hats that I can see is that, for example, in September 2017, Governor Alstott appointed him to be the Arkansas State Board of Public Accountancy. And also in 2018, he was elected as the fellow by the American College of Trust and Estate Council. And a few other things that I'll just highlight one of the other things. For example, he was also voted Lawyer of the Year in Trust in Estates in Fayetteville in 2023, Lawyer of the Year in Tax Law in 2022, and Best Lawyers in America 2021, President for Business Organization, Tax Law, Trust, and Estates. So a long list. I wanted to highlight that just to say that he took the time to talk to us here today, when he could be doing many other things. So I just want to appreciate him for his time, and wanted to highlight that his expertise is focused on estate planning, probate, trust, administration, taxation laws, funding business laws, and also including mergers and acquisitions. So, if you're ready, then we'd love for you to come up. I'm gonna pass this around for anyone who hasn't checked in yet. Okay. So, thank you.
All right, thank you all for coming. Thanks for having me. I've heard great things about this group, just from the few I've talked to here so far. Today, this is a good sized group, so as I'm talking, I am saving time at the end for questions. But as I'm talking, if I say something, you have questions, please speak up. I don't mind you guys making this interactive to make sure you get something out of this, but just listen to me up here talk the whole time. Go to the next slide. All right, so the legal disclaimer today, everything is just for informational purposes. Don't take any of this as legal advice. Everybody's facts and circumstances are different, so just something I say general today may not be specific enough that it applies to you. So make sure you get good counsel before you start implementing anything we talk about today. All right. So when I tell people what I do, and I tell them I do estate planning, usually people laugh and say, well, when I get an estate, I'll give you a call. That's based on the misconception that people think estate planning is only for the ultra wealthy. That couldn't be more far from the truth. Even small estates can benefit from properly planning your estate. True, the larger the estate, more complex it is, the more planning we have to do. But even small estates can benefit from at least doing the basics of estate planning. So when we're talking about estate planning, what does that actually mean? So estate planning is the process by which we get the best utilization of assets while somebody's alive. So estate planning does have aspects for the person doing the planning while they're still here. It also ensures that we get the maximum, benefits that we're going to give to the beneficiaries. We don't want things going to taxes, to attorneys, to courts, everything else. We want to maximize what's being left, and we want to make sure those assets go where you want them to go. Make sure they get into the right hands in the proper way. So that's kind of the summary of what estate planning means. And for business owners like you, real estate owners, we also want to make sure that once we get the estate planning in place, we do the additional layer of looking at your entity documents, the investments you have, to make sure everything works hand in hand, to make sure that even your business interests do go where you want them to go in a maximized way. A lot of times people do the estate plan and they don't ever look at the business documents to make sure everything works hand in hand. It's very important that you and your clients do that. So what are some of the benefits of a properly implemented estate plan? First is succession planning. So this goes to the business interest. Have a lot of people come in and clients will just say, hey, we just want all of our kids to be treated equally, 50-50 between the two, and they can deal with it. If you're dealing with a business and maybe one child is active in that business, the other child isn't, the one that's getting half the interest is not active in the business, the one that's doing all the work when mom and dad are gone is going to despise that sibling that's not doing any work. So real thought needs to be given to where those interests are going, who's going to operate it, and who's going to be in control. So those things are very important to consider. So we want to make sure we get the business interest and the operational control into the right hands. Another big benefit is tax planning. And by this tax, I'm referring to the estate tax. So Arkansas does not have an estate tax at the state level, but the federal government does. And the federal government says as long as your estate does not exceed a certain threshold in any 1 year, you don't have to pay the estate tax that you're passing. That number this year is 12.92 million per person. So for a husband and wife, that's 24.84 million. And a lot of times people say, I'm not even close to that. Problem with the law, the way it's currently drafted, is come January 1 of 2026, that 12 million number now is going to revert down to 2010 levels, which is $5 million per person. They are going to adjust that number for inflation, and people that are starting to run some projections, we think that's going to fall between 7 and 8 million per person. So we do need to make sure you don't get too caught up on the big $13 million exemption. because it is going to be going down unless Congress acts, changes something. And as we see, Congress can't really act and do anything. And so with the estate planning, what we try to do is we minimize the amount of tax that's going to have to get paid. Once we minimize that amount down to as low as we can, then we try to defer paying that tax as long as we can. So kind of a two-pronged approach to the estate tax.
Hey, Dan, real quick, are the pictures, anything we allowed to be taken or not taken from the group? Any pictures of the slides?
No.
Okay.
Yeah.
Some speakers say, hey, this is private information, just as you go through.
No, take all the pictures you want.
All right, good.
Just not a-
Usually when Brian presents, he's like, don't take any pictures,
You gotta talk to his agent.
So Danny, real quick, though, you're saying, so that amount is dropping to $7 to $8 million per person.
In 2026, unless they come in and change the law.
So for planning purposes, what does that mean for individuals as far as in that planning process? I mean, so if it's, you know, because that's a significant change.
And anything be grandfathered in?
So what we're doing now with clients that have significant wealth, what we're trying to do is lock in these exemptions now. So 12.92 million. This estate tax exemption, they call it a unified credit, which means it can be used for gift tax purposes or estate tax purposes or a combination of the two. So what we can do is we can actually give away the 12.92 million now and lock in that exemption. And once we give those assets away, they're no longer subject to the estate tax. So even when they reduce the estate tax down to 7 to 8 million for the exemption, we've locked in our big $13 million exemption, and it can pass to future generations estate tax free. What we do for married couples is we'll have husband set up a trust for wife. He'll make a gift of the 12.92 million into a trust for her, so he doesn't lose access to anything. He's fully used his exemption. Then we'll have wife set up a trust for husband. She'll move in the 12.92 million into that trust. Now we fully sheltered the full $24.84 million. So even in 2026, when they reduce that, they can't take it away from us. It's locked in. So that's how we're grandfathering it.
Can that be a revocable trust?
No,
It has to be irrevocable.
irrevocable trust. When dad sets it up for mom, he has to relinquish all control to make sure it's a completed gift, so that we don't have it pulled back into his estate. But as long as husband and wife are married, and neither one's mad at each other, they still have full access indirectly to the other one, through, backdoor access to those trusts.
Does it have to be husband and wife? Can I do that for my cats?
For your cat,
Yeah.
you'd have to think of a trustee, that wanted to take care of your cat with that kind of money.
You can sell that in suit.
Arkansas allows pet trust, so you can do.
There you go.
You can do pet trust.
$25 million cat.
Not really good.
Any other questions on that?
Are you seeing a mad dash of people moving company assets like a privately held C4? So we're going to give the shares to our kids, that way the tax is minimal.
So we are doing quite a bit of that. Liquid assets are typically easier to transfer just because the valuation's easy. But if we're doing privately held companies, we do have to go get an appraisal. Sometimes those appraisals of private companies run $50,000, $60,000, $70,000. And so sometimes people just don't want to do that. But something we're going to talk about towards kind of the end of this program is when you're giving away private companies, we get to actually leverage that exemption. So if we're claiming that, there's $1 million company and we're transferring a minority ownership in that, you get to take discounts off that company. So we can actually give more to future future generations without using as much exemption. So yes, that's certainly what my preference is, to do closely held companies, because we can give more with those discounts. If you give cash, it's just dollar for dollar.
Because we've done before getting married and what would change after getting married to this.
Well, if she decides not to marry you, you're in big trouble. We can't guarantee that it's going to be there for you, so I probably wouldn't do that. But that's always the risk, even for married couples. I say, I can't guarantee what's going to happen if the two of you get a divorce. Because what we have to do on this type of planning is husband has to set one up for wife or vice versa. We have to put some time in between. We can't do it at the same time. So while we're waiting in that time period, and I like to do it 2 different years, so it's on 2 different gift tax returns. If something were to happen to you in between before the other one gets set up, you might just be out $13 million. So I always have to disclose that to clients. But we have until January 1 of 2026 to get this in place. So we just get married before then. Get a prenup.
Prenup affects that.
We would just say, in the prenup is any gifts that are given to you during the marriage, that's gonna be considered your property on equal division, so that an equal number comes back to me. We do something like that.
Hey, wait a second, I'm just saying.
As far as like the trust, I understand like doing it in the wife and husband's name. Have you ever used ILITs or FLPs to like still maintain them? Like control, and that might be coming up.
Y'all are stealing all my money.
I'm sorry.
That's coming up, yes.
Okay.
You do more than just individual planning, like you mentioned business planning too as well, like so if someone, you know, at Elevate CIG, there's 3 partners who have equity in the company, so if one of the partners dies, what happens from that? We do some of that planning too on the business side.
And we're gonna talk about that today too. All right, so another benefit in addition to the estate tax planning is probate avoidance. So all of you are in real estate, you probably have deals that have been tied up in probate. So you probably heard the horror stories or actually experienced it. But probate is the court proceeding that oversees transfer and title from a deceased person to the proper beneficiary. In Arkansas, probate is guaranteed to last at least 6 months. It's usually 9 to 12 to 15 months, and that's when everything goes smoothly. During that 9 to 12 to 15 month period, someone like me, we have our hand out the entire time wanting to get paid. As a general rule, I tell clients about 6% of what goes through that probate process goes to pay attorneys, executors, and court costs. That is a very easy 6% we can avoid just by keeping out of probate with the proper plan. Another benefit of estate planning is disability planning. So again, lifetime benefits for the person doing it. So if someone becomes incapacitated, with the proper planning, you're going to have people lined up to step in to take care of your financial, legal, and medical decisions. Also, there's legacy planning as the benefit. So if you haven't done your own estate planning, good news is the state of Arkansas has done one for you. There's some default rules out there that say if you pass away without doing any planning, this is where we're going to send your assets. The problem with that default rule in Arkansas is it's not usually what someone would want. As generally speaking, husband and wife, if husband passes away, I always pick on the guy. He passes away first. Anything that was just in his name going through probate, as a general rule, the spouse is only entitled to 1/3 of it. 2/3 of it goes to the kids. If it's a harmonious family, usually we can get the kids to give it back to mom so she doesn't go hungry. But if it's a blended family, second marriage situation, things can get really sticky very quick. So by properly doing your estate planning, you can make sure your legacy is left to people you want it to be left to, and in the manner you want it to be divvied out.
Could the probate be avoided if you have like a will that really says who gets what?
A will is not valid until it goes through probate. So a will does not avoid probate. That's a big misconception people have.
Trust does, but it will not.
Correct.
Okay.
And then Danny, what about any life insurance policy? So again, going back to the said husband who passed away, there's a life insurance policy and that money comes in too. How's that? Is that kind of as part of the estate or is that kind of as just money that's coming into the beneficiary at that point?
So when we're talking about estate planning, there's 2 different estates that we have to worry about. One is a probate estate and one is the taxable estate for estate tax purposes. Life insurance without proper planning is included in the taxable estate for estate tax purposes. Okay. Life insurance, when you set that policy up, they usually give you a contract called a beneficiary designation form, and it says who your beneficiary is. If you've completed that, it passes outside of the probate estate. So it does not have to go through probate. And then another benefit of properly doing an estate is just giving peace to the family. So if someone passes away, emotions are high. When money's involved, emotions are high. So when you put those 2 together, it's just a breeding ground for dispute. If things aren't clearly outlined how you want things to be divided, siblings, parents, everyone else can come in and really start arguing. So properly doing the estate planning where we line everything out fairly clearly, you're giving your family a huge gift just of peace. So hopefully people like me don't have to get involved to get everything distributed.
But you can set life insurance up through a irrevocable trust to keep it out of the state tax revenue.
Yes, sir. All right, so what are some common documents that we use to plan an estate? And then we're going to go into detail on each one of these. The big centerpiece of most estate plans I do is a revocable trust. Along with the trust, we typically will do just a last will and testament. Along with that, we'll do a financial power of attorney, also do a healthcare power of attorney. We'll do an advanced directive. A lot of people refer to that as the living will. For some estates, we will do the irrevocable life insurance trust, a couple of you have just mentioned. And then for the business owners, we want to make sure we look at all the company documents to make sure they work hand in hand with the estate planning that we're trying to do. So we'll dive into each of these. First is the revocable trust. Most of the time, when I talk about a trust, people, they've heard of them, they don't really fully comprehend what it means to have a trust. But I tell my clients the best way to think of a trust is to think of it as a basket. Once we get this basket in place, the job for me, the client, or other advisors is we need to get all of their assets put into that basket. Once they're in that basket, they no longer have to go through the probate process. So it's very important, once that trust is set up, to get it filled up. Once we get this basket set up, there's going to be three parties involved. First is the grantor. That's the person that's setting the trust up. Second, once we get assets put into this basket, we need a manager of that basket. That person's called the trustee. For the revocable trust, the grantor and the trustee are usually the same person. And then once we get assets put into that basket, we need somebody that benefits from that basket. That's called the beneficiary. With the revocable trust, the grantor is also the beneficiary. So my elderly clients, when I start talking about a revocable trust to them, tell them we're going to put assets into the basket, they kind of get a little nervous because they think they're going to lose control. On a revocable trust, the grantor doesn't lose control of anything. They can put assets in, take them out, they retain the ability to revoke the trust completely, they can amend the trust, they can do whatever they want. This just sits here for them that they're in complete control of in case something unexpected does happen. Then we have all the planning built into that trust that states what the grantor wants to happen. Several benefits to a revocable trust. So I recommend the revocable trust. Some of the irrevocable life insurance trusts and the other more fancy trusts aren't for everyone, but this is something that pretty much any estate can benefit from. So some of the benefits of a trust, anything in that basket, if the grantor were to become incapacitated, everything is immediately available for the grantor. So when we set these trusts up, the grantor is the initial trustee, but the grantor is going to pick successor trustees. So if he can't serve himself, he's going to designate who can step in to serve whenever he can't serve. So if dad were to get sick, get dementia, can't handle his affairs anymore, we have a successor trustee that steps in, immediately can use those assets for the benefit of dad. Another big benefit is anything in this trust avoids the time and expense of probate. We just talked about that, so we want to make sure we get everything either put into the trust, or we want to do beneficiary designations on life insurance, retirement plans, different types of assets that say at my passing, those assets will jump into the trust, just to make sure none of those go through probate. Good thing about a trust is it's a private document. It doesn't have to get filed anywhere. Anything that goes through probate is public. It gets public record. And there are people in this world that are so bored, they will go down to the probate clerk, ask to see the probate book, and they can see where all these assets are going, who's getting the dollar values, because all that's public record once that we go to and file the probate. The trust doesn't have to get filed anywhere, so all of your family details stay private. Another big benefit is that this trust, after the grantor passes away, it's going to become irrevocable, which means no one can come in and change the trust. So the grantor's wishes are set in stone. And the grantor gets to decide how those assets are going to come out to the beneficiaries. I review a lot of trusts prepared by other attorneys, especially in Northwest Arkansas. And usually what the trust will say is after mom and dad are gone, we'll divide everything among the kids. Once they hit certain ages, 30, 35, 40, whatever it may be, let's just give them a third at 30, a third at 35, and the rest of it at 40. My recommendation to my clients is we don't ever do that. Because if we properly design this trust for the beneficiaries after the grantor was gone, we can get three really big protections for those beneficiaries. One, we leave it in trust. If the beneficiary were to get sued for any reason, if they lose that lawsuit, anything held in that trust, the plaintiff in the lawsuit cannot reach those assets as protected. If instead that trust says, give Bobby, a third of the assets, he was going through a lawsuit, the plaintiff in that lawsuit could reach in to grab those funds to satisfy their judgment. Second big protection is protection from divorces. So if any beneficiary were to ever get a divorce, anything held in that trust, the beneficiary's ex-spouse can't touch anything. A third protection, and coming from real estate investors, you're not going to like to hear this one. But if any beneficiary, for whatever reason, couldn't pay their debts and need to file bankruptcy, anything held in their trust, the bankruptcy trustee can't touch it. It's protected. So if you keep the assets in trust for your beneficiaries, you can give them those protections. If your estate planning through a beneficiary designation or through the trust or through a will just says hand it to them, As soon as it's in their hands, we've lost all those protections. So if you have your estate planning, you're talking to someone, make sure you tell them you want those protections for the kids. The kids can step in at some age and you get to decide that age. They can be their own trustees. They can be in complete control of those assets, so they don't have to go talk to somebody else to get access to them. Even though they're their own trustee, the creditors still can't reach those assets, so they're protected. So just make sure that those, you know, that those abilities are there. And then the last benefit we'll talk about is with this revocable trust. So for a married couple, we can do some estate tax deferral inside that revocable trust that says, no matter how many assets are in this trust or how big or small that estate tax exemption gets, we can, in that revocable trust, defer payment of any estate taxes until the surviving spouse passes away. So that gives us additional time to plan that we can just guarantee the estate tax at the first passing will always be $0. The example I'm talking about today, I've just assumed that there's going to be, one trust for dad. He's the sole grantor, he's the sole beneficiary, he's the sole trustee. For married couples, it's also possible to do what I refer to as a joint trust. So husband and wife will just set up one basket. Husband and wife will both be the grantors, they'll both be the trustees, they'll both be the beneficiaries. For married couples, you're just filling up one basket. For some estates, couples like to have two separate trusts, and that's fine, but then husband and wife have to have that uncomfortable conversation at dinner saying, this is mine, this is yours, and that doesn't tend to end well. But you can't have just one basket for husband and wife to fill the same one. And with trust, as kind of touched on, one of the biggest mistakes I see with those is people come in, see me, get the trust in place, they don't ever fill their basket up. Once this basket is set up, it is so important to go to step number 2, which is trust funding, getting everything put into the basket. You're sitting there with an empty basket, we're not getting all the benefits of a trust. So it's so important to do that step number 2 to make sure we get it filled up.
And you're just talking about deeding properties into the trust.
Deeding properties, if you own an LLC, put the LLC ownership into the trust, into the trust, investment account, everything.
Let's go ahead and broach this topic before we get too far down the line. If you're banker here, guys, in the corner of the room, if all your assets are involved in trust, a lot of these financial institutions are going to want guarantees. I'd love to hear more of where you're leaning towards how to get out of that. Of course, I have my ideas.
So with the revocable trust, that doesn't really shield anything from bank's claims. I don't know which bank you're with, but 99% of the institutions in this area won't lend to a trust. They flat out tell the clients, if you lend to a trust, we're going to give you commercial terms. The way around that the bankers tell all my clients is, let's finance the property, let's close the property in your individual name, and then after closing, wait a few days, and then you can move it into your trust later. Always explain to my clients under all the loan documents that's an event of default. The bank always has the ability to call your loan if they find out you do it. But that's the workaround that most of my clients do. I've never had a bank come in on a revocable trust and ask for any personal guarantee.
What if your trust guarantees your business loan?
And everything in that trust is liable for that loan. And the asset, so if you were to pass away and it goes to your beneficiaries, there would be no asset protection like I just talked about, protection from creditors instead of personally guaranteed. The lender could come in and get the assets because of that personal guarantee.
I don't want to segue too soon, but that's why capital markets are so advantageous for borrowers that have non-recourse. We can get to that some other time.
So a revocable trust can own an investment or can?
Yeah, absolutely.
The only asset we cannot put into a trust under law is retirement accounts, 401k, IRA. Federal law says the participant has to be the owner of that account. But what we can do is alter the beneficiary designations. Instead of it going to your kids, we name your trust. There are income tax advantages to naming a spouse. So my recommendation on retirement accounts is you keep spouse 100% primary, but we would put the trust as 100% contingent.
How easy is it to change the beneficiary?
Very easy.
Is there ever a time where the former beneficiary sued to say that the grantor wasn't in his right mind when he changed it?
That can always, I can't say that will never happen.
talking about your cat again?
She just been declawed.
Yeah, I can't ever tell someone you won't get sued because people can come up.
Because you say it's very easy. so easily changed. So I wonder if there's like a process to go through to say this person's in his right mind before you change it.
So a lot of times those beneficiary designations are changed with the financial institutions. The client will pick up their advisor and say, hey, I need to do beneficiary change for my IRA, whatever it is. And then if there is a lawsuit, then that advisor gets called to court and they have to testify that mom or dad knew what they were doing. All right, next document is a last will and testament. So one of the big benefits of the trust is probate avoidance. We want to make sure we get all the assets put into the trust. If you end up doing a revocable trust, we still do a very simple will to the side of that trust. It's what I refer to as a pour-over will. It simply says, even though Denny told the client 4 million times, think of the trust as a basket and you get all the assets put into the basket, that pour-over will is going to sit there as a safety net. If the grantor passes away and for whatever reason there was something not in the trust, the will says pick up those loose ends, pour it over into the trust so that the trust can distribute everything. The problem with the pour-over will is it does have to go through probate to get there. So we hope to never use that will. We hope it's a complete waste of paper, but it does sit there just to make sure everything will end up into the trust. If someone doesn't do a trust, they can still do a will, and it's what I refer to as a dispositive will, and it just says, okay, instead of distributing everything through the trust, we're going to have the will that sits here and distributes the property in accordance with mom or dad's wishes. It does have to go through probate to get there, but at least we're not relying on the default rules under the Arkansas laws to say where those properties are going to go.
Does it have to be, I've ran into this situation where it has to be recorded with the county first, or it's kind of deemed valid?
No, so you can file it in advance. I've never had a client do that. But after you die, we do have to file with the probate court to get the probate process started. So that's when it becomes a public record. I don't like to file it in advance because mom and dads tend to change their mind. We don't want kids seeing the old prior ones.
Yeah, that makes sense.
You'll go through a process, your institution goes through a process where y'all are kind of pulling records annually. Like, hey, y'all bought all these properties, you put them in your personal name instead of the trust. You know, you come in and let's talk about that.
You can come up with a system for us, you can make a lot of money. There's no way of us to be able to track that. I mean, we have clients all over the country, buying property all over the country, and it's awesome.
I think like GIS data and that kind of stuff, something you don't have access to regularly.
Maybe we can, but we have to know to go look.
Yeah.
We would need some alert that says, hey, you know, Bob just bought a piece of property in Florida. We have to go find it, but I don't know of anything that does it. You are the real estate folks, yeah.
Doesn't exist.
Yeah,
That'd be a lot of work. That's called
That's
called a CPA.
So my advice to my clients, anytime you're opening a financial account or buying real estate or buying into a business, shoot me an email, tell me what you're doing. I'll reply. I'm not going to bill you for it. Let me just tell you what to do. That way it kind of hopefully addresses that so they're not afraid to ask a question. All right, next document is a financial power of attorney. So what this is doing, so whoever's setting up the document, call them the principal. They are stating if they become incapacitated for whatever reason, old age, dementia, bumped on the head, car wreck, whatever it may be, this is who you want to step into your shoes to make financial and legal decisions on the principal's behalf. The benefit of doing financial power of attorney is that if you don't have this in place and dad does need somebody to step in and make financial and legal decisions, we have to go through the court system for a guardianship hearing. Guardianship hearings are never pleasant because we actually have to put dad on the stand, have doctors come in, a judge will declare him incompetent. It's all public record, so everyone gets to see that dad's now incompetent. And then it kind of opens up the floodgates for kids and everyone else to come in and kind of fight over who's going to be the guardian. So if multiple kids want to be the guardian for dad, it becomes a mudslinging fest where everybody's saying bad things about the other ones, hoping that they look the best. If you have this power of attorney in place, you can avoid that guardianship mess. And then one thing you probably be wondering, it says durable up there. You may say, what the heck does durable mean? So in the old common law, when someone did a power of attorney, when the principal set one up, what the common law says, once the principal becomes incapacitated, the power of attorney is no longer valid. It's null and void. You can't use it anymore. What states started doing to change the power of attorney is they came in and said, so what the states came in to do, they started enacting statutes that says okay, even if the principal becomes incapacitated, we're gonna allow these to continue on, and they just refer to that as durable. So it just simply means the power of attorney will continue even if the principal becomes incapacitated. Similar document is dealing with healthcare. So as long as the principal can make their own healthcare decisions, give the doctor the thumbs up, they're in complete control of all their own healthcare decisions. If they can't for any reason, this document is telling the doctors to come talk to these people about routine healthcare decisions. So the example I always give is dad's in a car wreck, he bumps his head, he's in a coma for 2 weeks, he's gonna be fine, but he broke his leg. This is telling the doctors to come talk to these people about surgery, medicine, just routine healthcare decisions. Again, without this document, we have to go to the court system to get a guardian appointed, and it's just a mudslinging fest that you'd like to avoid. Next document is the advanced directive. A lot of people refer to this as the living will. This one works hand in hand with the healthcare power of attorney. So the healthcare power of attorney was dealing with the routine healthcare decisions. This one's dealing with the end of life decisions. If you sign a living will, this is your instructions to your doctors that if they agree you have a terminal condition or are currently unconscious, and they have you hooked up to the ventilator, the feeding tube, the IVs in your arm, if your doctors believe you're not coming back and the only thing all those machines are doing, and you sign this document, you're telling them what you want to be withheld and what you want to keep going. So it's you making those end of life decisions. Benefit of doing this is without it, they're going to come to your loved ones and say, we don't think dad's coming back. What do you want us to do? It's always a difficult decision because a lot of times you don't really know what the parent might have wanted. And then there's a little bit of guilt no matter which way you go as to whether we acted too quickly or not. With this, you take all that off of the family so they don't have to make that decision. If the family can't come to an agreement on what's going to happen, there's the potential for this to end up in court for a judge to decide. I don't know if you guys remember the Terry Schiavo case down in Florida in the early 2000s. There was a lady on life support, her estranged husband. The doctors came to him, said what he wants to do. He said, take her off. The parents came in, said they're estranged, don't let him decide. That ended up in a 7-year legal battle where she stayed on life support for that long. After 7 years, the court finally said, okay, husband, you get to make this decision. He took her off and then she passed away at a fairly recent time after that. One thing I always like to point out to clients is this document is different than a DNR. So a DNR is a do not resuscitate. With the DNR, if I sign one of those, if my heart quits or I quit breathing and fall on the floor, what that's telling the EMTs is don't revive me, don't come shock me, don't give me CPR, don't do anything to bring me back. An advanced directive is not a DNR. Even with an advanced directive, if the heart stops, you quit breathing, they're still going to come do all they can to bring you back. If they bring you back, if there's no brain activity going on, they're just laying there in a vegetative state, that's when this would kick in. So they're still going to do all they can to save you, but if they do bring you back, if there's nothing happening, that's when this would kick in. All right, next is the irrevocable life insurance trust. It's been mentioned a couple of times. So life insurance, as a general rule, is not subject to income tax. So whenever that death benefit gets paid to a beneficiary, the beneficiary typically does not pay income tax on it. But for estate tax purposes, it is included in the owner's estate. So what we'll do with the life insurance trust is we'll actually change ownership of that policy, put it into this islet so that it's no longer subject to estate tax. So once that death benefit pays into the trust, it's not subject to income tax, it's not subject to estate tax. So it really preserves the death benefit. One thing to keep in mind about insurance is a lot of times people, especially the real estate folks, when they're doing their personal financial statements, they might list life insurance there, but they always list the cash surrender value. If you have a $5 million policy for a death benefit, that's what we need to be looking at for estate tax purposes, not the cash surrender value. So when you're looking at the exemption amounts of what your estate is, make sure you're looking at the death benefit, not the cash surrender value. Questions about that? No, there were earlier.
Well, to that example, if you had a $5 million life insurance and you talk about the new limits, 6.7, I mean, you're there like that.
Right.
So 2026 is gonna be here before you know it. You don't make that change, right?
And one thing, if you have existing policies and we move them into an insurance trust, there's a 3-year waiting period before it's outside of your estate. So you have to make a transfer of that policy into the insurance trust and survive for 3 years. If you die within that 3-year window, the death benefit gets pulled back into the estate. So we do need to do some advanced planning. You can't wait till the last minute to try to do that.
Okay. What about changing the beneficiary? Is there any restrictions on? Update that.
So The trustee, who's gonna be the owner of the life insurance policy, they're gonna have a fiduciary duty to benefit the beneficiaries of that trust. So if the trustee were to come in and change the beneficiary to anything other than this trust, they'd be breaching their fiduciary duty.
So how do you get around as life changes with the name beneficiaries on the life insurance policy? How does that, how do you set that up so you say, okay, well, does that then fund another trust?
So typically the insurance trust will sit here, you'll have your revocable trust in here that says it's going to these people. And then a lot of times the insurance trust will have the same type of planning. It says this death benefit is going to go to these people. One of the big benefits of an insurance trust is it's a source of liquidity. So if we are having to pay the estate tax and the death benefit gets paid into the trust, it's a source of funds for the estate to use to pay estate taxes, to pay debts, whatever may need to be done. It just provides a very liquid source, so people don't have to go out and start selling assets to pay off any obligations. Another big reason we'll use insurance trusts for business owners is, you know, dad and one child are real active in a family business, and dad says, I want the business to go to that active child, but they have another kid over here that's not active, and they want to treat them as equally as possible. So we can actually set up the insurance trust to receive this death benefit, and the insurance trust will be only for that other child, just to try to equalize what's happening in the family. But to change beneficiaries, there are ways to change even an irrevocable trust. We build in flexibility so that can still be done. All right, so we kind of talked about the basics of estate planning, the documents that a lot of people want to do. For the business owners, kind of start looking at that piece of the puzzle. So when you're deciding you want to set up a business, and I imagine most of you have already been through this process, the first decision is what type of entity do I want to set up? And there's quite a few different options. Reasons that we like to set up these entities is liability protection. So if the entity is set up correctly, operated correctly, anything that might happen to that entity, so we have an LLC and it gets sued, if everything's been operated correctly with that LLC and you lose that lawsuit, the plaintiff of that lawsuit can only get what's in that LLC. It can't go after the personal assets of the owners of that LLC. So that's why we like to do these with the liability protection. So kind of give some considerations to what type of entity you might want to do. So the first one is a sole proprietorship. No filing is done with Secretary of State. This is just a person operating a business in their own personal name. This is very easy and efficient from a legal and tax perspective, but it offers no liability protection. So this is something you're not going to want to do. Another similar concept is just a general partnership. So if two buddies go together and operate a business, they go buy a rent house, start renting it out just in their names. That's just a general partnership. No filings are required for that to set that up. But the downside to that is neither of the partners are going to have any liability protection. If they get sued, all their personal assets are at risk. Another option is a limited partnership. So this will be the LP that you'll see at the end of entity names. This does require a filing with the Secretary of State to set up the LP, the limited partnership. With the limited partnership, you're going to have one general partner, at least one general partner. The general partner handles all the day-to-day controlling decisions of the partnership. And you're also going to have at least one limited partner. They're the silent person. They just sit there, they take distributions whenever the general partner decides to make them. With the LP, the limited partner does have liability protection, but the general partner does not. So the general partner doesn't get any personal protection from having that entity set up. So you're not going to see very many LPs. Another option is a limited liability partnership. Again, this one does take a filing with the Secretary of State's office. With this one, it's either a converted LP where the general partner says, hey, I want to get personal protection, so we convert that LP to the LLP. Or if it's just an LLP on day one, we don't typically have the general partner limited partnership distinction. It's just two partners, and the partners of this LLP do enjoy personal liability protection. Another one is a limited liability limited partnership. So this is the LLLP. With the LLLP, you're going to have a general partner. You're going to have at least one limited partner. You can have multiple general partners. Again, the general partner controls all the decisions of the partnership. The limited partner just sits there as a silent person that gets distributions when the general partner decides to do it. Both the general partner and a limited partner both get liability protection with the LLLP. So some of y'all's investments, I don't know if your syndications, a lot of times will do the LLPs, just so that there is that general partner making all the decisions, and all the investors out there are just limited partners sitting there getting what they get. And there was the question, who had the FLP question? So whenever we do FLP, so the family limited partnership, there's no such entity called FLP or family limited partnership. Us estate planning nerds, we just like to make up names to make ourselves feel better, and family limited partnership is one of those. But with the family limited partnership, we will set it up as an LLLP so that there's a general partner and a limited partner, at least one of each. And with the family limited partnership, what typically happens is senior generation, grandma, grandpa, dad, mom, whoever it is, they will set this up, and on day one, a lot of times, they will have all the general partnership interest. They control the entity. They'll also have all the limited partnership interest. But with this limited partnership interest, they can start transferring that to future generations at a reduced estate tax cost. Reason for that is because the limited partners don't have any control over what's going on. Another big reason is whoever's owning this limited partnership interest can't go out and sell it anywhere. So there's lack of control and there's lack of marketability. Due to those two factors, we get to discount for valuation purposes the value of that limited partnership interest 30 to 45% in the system. So it really allows us to give a whole lot more by giving away those limited partnership interests once we factor in that discount. So just for an example, so if we have a farm in an FLP with $1 million farm in it, and grandma wants to give grandson a 25% limited partnership interest, it's not worth $250,000. We get to subtract about 45% off that value for federal estate and gift tax purposes. So we get to move a whole lot more value outside the estate just by giving away that LP interest. Can I answer your question?
Yeah, no,
The general, in that instance, then would grandson be taxed on that?
So there's no income tax on gifts.
Okay.
If there is a gift tax that has to be paid, the donor has to pay the gift tax. But typically when we're doing gifting, we make sure that there's no gift taxes.
How does that work with the limit gift tax?
So we have the 12.92 million this year, so we can give up to that much and not pay any gift tax. So typically what we do on these closely held entities that we're gifting away is we do formula transfers. We say grandma's transferring the maximum number of limited partnership units that won't trigger gift tax. We think that is X number of units. We file that on a gift tax return. If the IRS comes in and audits us and say, we don't agree with your valuation, it's worth way more, and we say, fine, you win, but we're going to adjust down based on this formula, having to be transferred so that there's no gift tax owed. All right, so the FLP, that was just kind of a side note. Another entity that you can choose when you're setting up a business, the LLC. This is what most people are familiar with. They're very common. They're very flexible. Of the LLC, you can have one or more members. Once the members set this up, you can decide if the members are going to manage the company or if they're going to separate it and have managers actually step in and manage it. So you get to dictate all that on the formation side when you're setting up that LLC. Final document is a corporation. Corporations, they are very old. You don't really see a whole lot of corporations getting formed new anymore, unless the plan is to take this company public or it's going to be sold to private equity. So we don't set up a whole lot of corporations now. With corporations, there's a lot of formal requirements under Arkansas code. You have to have annual meetings. You got to keep records of those annual meetings. If you don't do that and there ever is a lawsuit, first thing a plaintiff's attorney says is give me the corporate book, because they want to see that you've been doing all these record keepings that are required. If you haven't done it, that's when those snake plaintiff attorneys try to come in and pierce the bell of the company to get after the personal assets of the shareholders. So with the corporation, there's a lot of formality you want to make sure you're following. With the partnerships and the LLCs, there's no similar requirements. You have those annual meetings, so just less formality with those. Once you decide on the type of entity you want to set up, then we have to decide how the entities can be taxed. So for sole proprietors or for a single member LLC, the default rule is that this is going to be a disregarded entity. What that means for tax purposes is that we act like it doesn't even exist. All the income deductions, losses from that entity just flow through to that single member's personal tax return. So no separate tax returns required. Second option is a partnership. So if we have a multi-member LLC or any of those partnerships I talked about, the default rule on those is it's going to be taxed as a partnership. A partnership is a pass-through entity, which means there's no tax at the partnership level. Instead, it files a Form 1065. All the income deductions, losses, all flow to that Form 1065. CPAs run through the calculations. Whatever the net result is, it gets shot out to the partners or the owners of that LLC on a K-1. And then the owners of that company have to pay the tax or report the losses or do whatever needs to be done on their own personal return. Another option is an S corporation. I get calls frequently from people that say, hey, I need you to set me up an S corporation. Well, we just went through those types of entities. There's no such type of entity as an S corporation. An S corporation is simply a tax election. With an S corporation, you can elect to have a corporation or an LLC be taxed as an S corporation. The reason a lot of CPAs in this area love the S corps is for potential on self-employment taxes. So any money that passes through a partnership, that money is 100% taxed as self-employment income. So that's 15.3% tax on top of the income tax. What people like to play on the S corp game is they will pay themselves a reasonable salary out of the S corp. You pay the 15.3% on that. Any additional distributions on top of that reasonable salary is not subject to the 15.3% self-employment tax. The IRS does not like that game. So if you're trying to play that, make sure you talk to your advisors to make sure you're setting a reasonable salary that's going to pass muster on an audit. On an S corporation for real estate holdings, if you have raw land, it's fine. But if you have land with an improvement on it and you're taking depreciation deductions on that real estate, you want to make sure those are not in an S corporation. So if I have an S corp set up, I'm the sole member and I have a piece of property in there that I've been depreciating, I can't distribute that piece of property out to myself without triggering tax. So you lock in this potential gain and there's not a lot of flexibility you can do with it. So for real estate holding companies, don't make it an S corporation. If we want to play that self-employment game, we set up a property management company over here that doesn't own any real estate. And then we just enter into property management agreements with those property holding companies, and we can get around those rules and potentially play that game. And then finally, there's a C corporation. So if you set up a corporation, the default rule is a C corp. You can elect to have it taxed as an S corp. A corporation is not a pass-through entity, or a C corp is not, which means once we put all of the information into the tax return, that tax return is going to spit out a tax due. So the C corp itself has to pay taxes. And then once distributions are made to shareholders, they potentially have to pay taxes again. So there's a double layer of tax with the C corporation. That's why we don't see a whole lot of these. At the federal level, the C corporation tax rate is 21%. And then potentially the dividends coming out can get taxed at 0, 15, or 20% to the shareholder, depending on their income tax bracket. So there's the potential that you're paying 41% just at the federal level on the C corp income. On the pass-throughs, the highest you're going to pay on those is 37%. So there can be a little bit of tax disadvantage to the C corp. All right. So once we've decided on the type of entity, how we want it to be taxed, then it's very important to make sure you have entity documents put in place. So for a partnership, you want to have a partnership agreement. For an LLC, you want to have an operating agreement. For a corporation, you want to make sure you have bylaws and a shareholder agreement. In those documents, it's going to specify all the ground rules with these entities. Who gets to make decisions, what type of votes required, who's in control, who's the owners, all of that's going to be spelled out. So it's very important that those get in place. Within these documents, you're going to want to make sure there's some buy-sell provisions. What the buy-sell provisions are going to do is it's going to restrict who can become owners, and it's also going to have certain triggers to say, if this were to happen, the company or the other owners of this company are going to have a right to come buy you out. Common triggers that we'll have is death. So if one of the members passes away, and as part of their estate planning, they say, all my ownership in the company is going to go to my wife, but the other members don't want to be in business with the wife. This is going to give the company or the other members the right to come in and buy them out. Another common trigger is divorce. So if a member is going through a divorce, and as part of that divorce settlement property agreement, part of this ownership of the company is going to go to the ex-spouse, and the other people don't want to be in business with the ex-spouse. It's going to give them the right to come in and buy them out. Another common trigger is incapacity. So one of the owners becomes incapacitated and is no longer contributing to the company, just sitting there potentially taking their share of the profits. People don't typically like that, so this will give the other members of the company the right to come in and buy them out. Another thing the buy-sell provisions will do, in addition to setting the triggering events, it's also going to set the purchase price. Either we're going to say the purchase price is X dollars, and we might do some type of an adjustment, say every year it's going to increase by 3%, or we're going to at least come up with a formula that says this is how we're going to determine the purchase price. Either the CPA comes in and figures it out, we go get an appraisal, we come up with some valuation mechanism to make sure everybody knows when that time comes, this is how we're going to determine purchase price. And once we determine the purchase price, the buy-sell provisions will also say how that's going to get paid. If 100% of that purchase price has to get paid at closing, that can put the company or the other members in a cash crunch where they really can't afford to do it. So a lot of times what we'll do is we'll say, okay, let's pay 10% down. The remaining 90% gets paid over the next 5 years with an interest component. So it just lightens the load on making that purchase if it ever needs to be done. So the biggest mistakes that I do see with people that are operating entities, we'll just talk about LLCs right now, is putting too many properties in the LLCs. I have clients come to me, they might have 30 properties and it's all of one LLC. One big benefit of the LLC is if anyone ever wants to sue the owner of the property, they can only get to what's in that LLC. If you have 30 properties there, they can get to 30 properties. So, mitigating your risk, separate it out into multiple LLCs. The lawyer answer, people always ask, how many should I put in each LLC? The lawyer answer is one in each LLC. But practically speaking, that never happens. So you can just decide what my risk tolerance is, put that much value in this LLC, and then kind of separate it out. So that if any one LLC does ever get sued and they lose, they can only get to what's in that one LLC. Another benefit or another problem that I see is people not doing an operating agreement. Setting up these entities with the Secretary of State is super simple. You go online, spend 10 minutes. And so I have a lot of people that go do it themselves. That's fine. The problem is they don't follow that up afterwards and get a good operating agreement in place for that LLC. So there's no rules. When you and your buddy are starting a business, your friends, everything's great. You don't think there's ever going to be issues. You don't need an operating agreement. That's fine until things go south. If people start fighting, that's when you're going to wish you had an operating agreement in place that specifies what's going to happen. So make sure you get that in place. And as the company matures and keeps going on, make sure you keep those operating agreements updated. So if you change members, you have different people joining, make sure all those are updated to reflect the accurate ownership of the company and how things are operating.
How do lawyers work with an LLC within a trust?
So I would typically put the ownership of the LLC into the basket so that the trust is the member. And then a lot of times with that LLC, we'll have a manager manage so that whoever wants to manage the LLC, it's usually the grantor, is the manager. So they can handle all the LLC affairs without dealing with the trust.
So then if you're sued, do they have access to everything within the trust?
As long as they don't pierce the veil of that LLC, no. So, but if they pierce the veil, yes, they could. But the revocable trust sitting there, if the ownership was just in your name and they pierce the veil, they could still get to the trust. There's really no downside having it in the trust. Then the last problem I see with LLCs is, as I was telling you, what a lot of bankers will tell my clients is, people want to go buy this rent house, they go talk to their banker and they say, hey, we just set up this LLC, we want to put it in the name of this LLC. Banker say, well, you do that, we can't give you this good rate. So why don't you just close it in your name? Don't tell me about it. 30 days later, move it into the LLC. People go close it in their individual name, and then they forget about the LLC. They're operating their LLC, they're doing the lease agreement LLC, everything's in the LLC name, but they don't have the properties in the LLC. So a lot of times when people start telling me they have these rent houses, I'll go pull all the real estate deeds just to make sure titling is actually into that LLC. You don't move the property into the LLC and there's a lawsuit, they're going to sue the owner of the property. That's in your personal name. All of a sudden, you're personally liable for that lawsuit. So make sure the properties actually get put into that LLC.
I think the deed of the property is in the.
Correct, yes.
You need to have a good title company to trust.
I had to do one, but then the loan was under my name because at the time I didn't have the business. So what's under my name, so the deed had actually come sold to me, and then I had to go find the title person to deed it over. But then there's a due on sale clause that the bank technically could go back and say, you owe me all this money because it transferred ownership. But most don't do that. You just have to be careful.
In 17 years, I've had one lender catch a client.
Yeah, the lender, if they catch it and they want to make it difficult, they can do that.
So,
Use the due on sale clause.
And one issue we're having right now is people have a lot of locked in low rates.
Yes.
And lenders right now are going to be very incentivized to say, well, we see you put this in a trust, you put this in an LLC. You pay us off or refinance the loan.
Yeah.
And we're going to refinance you at 8%. So there is a big, there for a while, there wasn't any incentive for them to do that.
Yeah.
Now there is.
If you incorporate in a more tax advantageous state, it's still exposed to Arkansas tax, depending on what your activities are.
I mean, if you're a resident here and you're pulling money out of, an LLC, you're still going to get taxed on it. If you're paying tax in that other state, on that same income, Arkansas will give you a credit to offset the double tax, but it's really hard to, as long as you're a resident here, to avoid the Arkansas tax. Move to Texas.
There you go.
Florida.
Do you see a lot of conversions from like C to this? There's a tax usually you pay a tax if you want to convert a private C corp into a S corp.
Yeah, we don't do a lot of that, just because I don't see a whole lot of C corps, period. And the ones we do see are so old and they're usually just farms that don't have anything in them to really cause a.
Well, Danny, we're thinking about a legacy structure where it's probably not advantageous for them to stay in C corp. What's the implications? That's the question.
Of converting.
Tax.
So I have to look at these rules. I hadn't done one in so long. So I can't answer that right now on what the conversion tax would be. But they don't like you monkeying around with the pass through to the C corp. If you do have a prior C corp, there's something called an accumulated adjustments account. And once it gets converted over to that S corp, that carries over to the S corp. And we have to look at that to determine when the tax has to get paid. I don't believe it's immediate, but it does carry over because you're locking in that C corp history.
Right.
Yep.
What about, keep meeting minutes from my LLC, just so, make sure that there's no chance of piercing the mail. Is that?
It's not required, meetings aren't required, it certainly doesn't help. I mean, that doesn't hurt, yeah.
How is it easy, how easy is it to pierce the mail of an LLC?
I mean, it's just, the important thing is to make sure you're keeping that entity totally separate. You have a bank account over there, you're respecting all the corporate documents with leases or anything else are done in that name, tenants are right name. Where you start getting in trouble is with the commingling personal accounts, business accounts. You have your debit card for your LLC. If you're going to Walmart buying groceries, they start looking at all that, unfavorably. I don't know of any cases in Arkansas that it's happened, but I don't do any of that type of work, so I wouldn't be the right one to ask. I'm sure it's happened, but it's typically the more egregious facts where people just totally disregarded it.
And one thing that somebody mentioned to me, I did, but on my rental house, I did transfer that house into the LLC, but then on my insurance is in my name, but I also did have my insurance company do additional insured with the LLC name. That way, if the insurance company, there's no issue. If they go and say, well, this LLC owns this, so.
That's a good point.
And do that with trust as well. So if you move property into a trust, like your home, make sure you add your trust as additional insurance.
That's very common, especially when there's a name payee coming to check on this.
Those lenders gotta watch out for them.
You were.
Hey, what?
You were speaking of interest rates earlier, and so, and how low interest rates have been, people walked in, you're probably gonna see a lot of accidental landlords, what they're being called. So transferring a personal asset into an LLC, are you seeing a lot of that right now, or to turn into like a real?
So just like residential properties.
Residential property getting converted into.
Maybe like a mom and pop or something, and they've never really thought about this before. You see more activity.
Yes.
Yeah.
I wouldn't say I've seen any more than normal.
Yeah.
I've seen a spike in it.
I'm not surprised.
Because most people are staying at their house right now.
Yes.
They can't afford to go
We
anywhere.
can't afford to go out and go there. Yeah.
When you set up an LLC, you can actually put the beneficiary in there. If you have an LLC inside a revocable trust and the revocable trust have some kind of beneficiary that contradicts, which one takes precedence?
Where are you putting the beneficiary of the LLC?
I had it when I was working with an attorney. She actually gave me a form to fill out the beneficiary for the LLC in there.
So if you put the ownership of the LLC into the trust is going to control. Because that beneficiary designation will say that Tina is the owner, but if you move it into the trust, you're no longer the owner, so your beneficiary designation.
So the LLC itself has a beneficiary in case something happens to me. So someone else would get it. What happens if I move that LLC into a trust and then somehow the trust gets a different beneficiary? Then the LLC no longer has that precedent. The trust does.
The trust would control it, right?
Mm-hmm.
All right. Any questions on this? I've gone over my time.
It's been really good.
I have a question. as somebody gets, I age or somebody, a parent that's aging, how do you protect assets from, you know, if they have to go to nursing homes, don't have long-term care insurance, what's vehicles to do that with?
So that's what we call elder law planning. I don't do any of the Medicaid planning. We have 3 guys in our firm that are excellent. They specialize in it. But Medicaid is a needs-based program, and if you have too many assets, DHS is going to step in and pay for anything. They make you spend your assets down to about $2,000, and you can't have more than $600 of income a month. If you exceed either of those, they're not going to pay. So they want you to spend your assets down. But these guys have all sorts of techniques that I don't understand of how they're able to preserve assets. It may not be all of them, but they can start taking some steps to plan.
So even when you set these up as people age, you may modify all that then as they get older to help in that protection.
So what we've talked about today is more of the foundational estate plan, just, you know, to cover the normal scenarios. If somebody has a stroke or they have Alzheimer's diagnosis and we say, hey, this is probably likely, then we might flip the switch and start doing more of the elder law planning to plan for Medicaid. There is a 5-year look back on that. So if you give assets away and somebody needs Medicaid within that 5-year period, there's a penalty to reduce your benefits. So it does take a little advanced planning.
You have a best in class, like frequency. So for instance, you set up a trust 5 years ago. You have a check-in that says, hey, we should really look at this, you know, every 5 years, every 3 years or something, or just income changes or.
So my advice to clients is if nothing big is changing your life, let's sit down every 3 to 5 years. Let me come in, tell you what your trust is saying. You tell me what's changed in your life and see if any updates are done. Once we get it in place the first time, changes are super tough. So 3 to 5 years is what I'm just going for a standard review. If something big happens before then, come in and see me before. When you are doing an estate plan, if you look at that 3 to 5 year horizon, it becomes a whole lot easier to make decisions. If you try to project out what you want to happen 30 years from now, you're going to get bogged down. But if you just looked at 3 to 5 years and just know you're going to be updating this over time, it becomes a whole lot more manageable to make decisions.
Yeah, one more question on the trust and LLC. So if in the LLC operating agreement, or in that structure, you're putting in there that the trust, it points toward the trust. Do you have to do anything inside the wording of the trust to receive those? Do those need to be named in the trust?
It depends. So if you want that ownership of the LLC to go to a specific person or to a specific group of people, yes, we need to say, okay, well, mom and dad are gone, it goes here. Also with businesses, what we'll do a lot of times, we'll put them in a trust. So maybe dad's the sole person working at the office and he wants to put this into the trust. If he passes away, he wants the trust to be the owner. Surrounding spouse is going to be the trustee of the trust. But dad may say, okay, my kids are the ones running it now. If I'm not here, I want them to step in and run it. So we may actually have a special trustee over here to the side just for that business. So we may designate, okay, this business is going to get run by these these other trustees, so that my surviving spouse who doesn't have a clue about the business isn't the one running.
Yeah. Me and my wife had discussions around how do you keep all these documents in place where she's like, I don't know half this way to do it. How do I know if you die, what am I gonna do? Just give it to them.
Yeah, that's right.
It's gone you.
It's funny.
I'll put your card in there.
Yeah, I'm actually working with some software people right now to do like an app website. It'll kind of be a place that everything like that can be stored. And I have access to it. I can update things for them. They can access to it. They can tell me what needs to be updated. So hopefully in the near term, that'll be up and going.
There's a question from the, all right. Yeah, I think.
Good or bad?
I mean, that was about the whole setup, but this is one of the best
Yeah.
estate planning sessions I've been to,
Yeah.
honestly. I've been to many, and whether hosting or being like a participant, it's one of the best ones. I don't know if everybody else, but really appreciate it, so.
A lot of work on with this hypothetical. We're not specifically talking about you. Exactly.
Well, thank you again, and we have this information, on there as well, if you have any more questions, come and talk to him. I do want to thank, Mike Dooley, for offering the space for us. Because probably know about the Dooley Group, do you want to just introduce a little bit about what you guys are doing?
I'll do, thank you guys for letting us be the host. One thing I would say that I love about commercial real estate, just a fun story. The building, you think this building's pretty nice, who likes the building, the renovations? What if I told you I got paid $55,000 to buy an 18,000 square foot building in Bentonville? How would that make you feel about commercial real estate? And that's what I love about it, I guess, the opportunities. It was kind of cool. I was able to owner finance the down payment. I was the buyer's agent. So, and then I was able to do the renovation, the tenant paid for it, and now raise the rents. I've received like 6 offers on this building. I don't plan on selling it, but still it's in a premium location. The only thing I would pay forward to you guys is sometimes just ask. I was nervous to ask, saying, hey, would they owner finance, would they not? And I just threw it out there like, of course. So I would just tell you in business a lot of times, just ask. And I think a lot of times we're scared to do that. As you think about this, and we have lenders too, but you think about this great environment that we live in. I think the best deals in the world are with great lenders and great partners. So sometimes just to ask. So we do have 9 companies in town. I'm actually our chairman for Keller Williams. So we have 310 agents in Northwest Arkansas, and Stillwell, Oklahoma is in our region. We added them most recently. But we have title, we have mortgage, we have insurance, we have next door, and you see a couple of inventions. I showed this one. But I would just say, hopefully I'm just a steward of saying, just go for it. So hopefully this is what I love about Brian and everything he's doing. He's gone for it, hasn't he? So I just appreciate being part of this. And if we can help in any way, if you ever want to use, I always say this, I'm big in charity, so I'm on the Make-A-Wish board. If you ever want to use one of the offices, we have 7 offices, we want to be part of the community, let us know anytime. We're happy to help. Because I think Northwest Arkansas, this is what I love about it. We're still small, even though we're growing every day, but how do you help each other? So just honored to be here. Thank you.
And next event's gonna be the second Tuesday in November. We don't have all the details yet, but I do want to highlight the students' contacts. You know, if you have any more detailed questions, I know a lot of you ask very specific questions, so definitely, we'll be able to help you out.
Thanks for having me.
Yeah, thank you so much for taking the time.
Have a good night.
Thank you.
Hey, Eric. Hey, nice to meet you.
Yes.